I'll do it. Hey, ladies and gentlemen, for a few minutes, we all have to do a spit test this morning, so.
Members had your COVID.
All right, ladies and gentlemen, apologize for the delay, but I think we're ready to get started now. Yesterday, we had some testimony from the public, and we're going to take up some more of that this morning. I'm going to have to limit everybody to about 3 minutes. I've got a timer running. It will alarm, so you'll know when your time is up. And we have a whole bunch of folks that want to talk, so I want to give everybody an opportunity if I can. But I got to save some time for us to have discussion among the committee, and there are several amendments that will be made to the bill. So with that, let's see. Start out with Dana Smith. You'll come up over here, please. All right, if you would state your name and then give us your statement.
My name is Dana Smith, and I'm from Hart County. And first of all, I'd like to thank the committee for the work that they're doing here. I would also like to thank Representative Powell and Representative Leverett, because they are the two representatives who worked with me on this chain of custody portion. I am the constituent that Representative Powell mentioned yesterday. I wanted to just give a little clarity on a couple things. With evidence, the way evidence from something like a crime scene, the way it's protected is there are 3 mechanisms that protect evidence. The first is that evidence is held in a secure area, like a secure evidence room. The second protection is that evidence is only handled by people who have sworn an oath to uphold the law. The third protection is detailed chain of custody. We have protected the paper ballot with the first 2 protections, but we have not protected it with detailed forensic chain of custody that protects evidence. The people's vote is not the machines. The machines are there for convenience. Their vote is that actual paper ballot that gets cast and scanned. It has to be protected in the same manner we would protect other evidence. Yesterday, I heard a lot of different testimony. I heard someone from the Board of Elections talking about, oh, we've had chain of custody this and chain of custody that. And the sad truth is that we don't. And I think that it comes down to an issue of not having a clear understanding of what chain of custody actually is. I brought just an example of how easy and cheap it is to secure these paper ballots. This is a secure sealed container. It is not expensive. It has a numbered seal, and it has a detailed chain of custody form documenting the seal number with witnesses. This process, this hand in hand of the seal or lock number and the detailed chain of custody form is what chain of custody is. It isn't someone saying, I promise I didn't mess with the ballots. It's not having them in a locked room. It's not taking an oath. It's this actual process. I would also like to just share with you, there was a lot of discussion yesterday about should there be chain of custody for the special paper that comes from the state to each of the counties for the ballots to be printed on. Let me just say, if it's special enough to come from the state and have special security features, then it is special enough to be secured with chain of custody. I have submitted for the record a sample of a detailed chain of custody form that I have designed that will meet all the requirements for the law, and counties are free and welcome to use it. The total cost involved in this is the cost of printing a chain of custody form and using it. Thank you.
Thank you, Ms. Smith. All right. Ted Metz. Oh, okay. Let's hold on, Mr. Metz.
Oh, you're back.
She said she had a question.
Thank you. Thank you, Mr. Chairman. Thank you for coming down and, giving us a better explanation. I would just have one concern about the container. And so since we're talking about how valuable these pieces of paper are, the ballots and everything, and I know you showed that paper box, but, considering that wherever they stored at and heat, humidity, do you think it would be better that we had something that was a little bit more sturdier so that, if there was a fire or if it rained or water got in there, that the paper would not be damaged? That's the only question I had for you.
Absolutely. That's a wonderful concern and a wonderful question. So I bring that box in. Many of the counties are small. Maybe their secure location is just a locked cupboard. Definitely, if the funding is there for that county, to have that, yes. A Rubbermaid tote that can be sealed and locked with a numbered lock, numbered seal. Yes, if you have that in the budget, it kind of, which calls just to mind the whole budgeting issue, which is just in some of the comments yesterday. As a voter, I guess I just always assumed that taxpayer dollars paid to run an election. Most people think that. So I actually appreciate the language in this bill restricting where all this outside money comes from, because I want it to be just as squeaky clean as it can possibly be for both sides. I don't know about each of you, but I personally never want to live through another election where whatever side loses said there was cheating. I never want to go through that again. And I don't think any of the rest of you do either. And that's why we're here. And that's what this bill is about. Thank
Chairman
you.
Powell.
I have a comment. I want to thank my colleague for making a comment about the boxes. When 886 was presented early in the session to the election subcommittee and the full committee of governmental affairs, we had discussed that it could be a paper box, it could be a plastic box, it could be any type of box prescribed by the local boards of elections. I think, for instance, that you could any of these hard container boxes, I think they have a cost of anywhere from $12 to $15 a box as a permanent type box. The paper boxes, of course, depends on the situation, but that would be left up to the state board of elections and the local boards as to how they would determine that. But that being said, since I have a constituent, Ms. Smith, I want to thank her, and just as a matter of reference to the committee members and those others, always be aware that sometimes you have a constituent that can come up with an idea that we have overlooked. And for that, I'm very grateful to her, because it took me a while to understand what she was talking about. And then once I saw her presentation, and I realized that we have a duty in what we've done last year and this year as a committee, that because of the division, because of the issues dealing with elections, that what we're trying to do is get to the point that everything is uniform, no matter what county it is, so that can dispel any of these the anxiety and the concerns that there's been something that's been done wrong. So if every county is doing it the same way, then that hopefully will take us a long way. Thank you.
Representative Alexander, is that you?
No,
Burnell.
it's me. Thank you.
Oh.
I just have one comment. Since we keep talking about uniformity, I really do think that whatever box that we use, it should be the same across the state. And then that way there's a consistency, because my county might go and buy the $33 container. Somebody else might use a box. And depending on what happens, then somebody could say, oh, you didn't do it the right way. I think if we kind of give some more specific guidelines, I think that would be better.
All right. Ladies and gentlemen, I'm jump around on the list here because I want to get both sides. I called Mr. Metz, so if you'll come up. Yes, you're fine.
All right, thank you. Thank you for allowing public testimony today. To address the paper box issue, it's very easy to line a plastic or a paper box with a kitchen trash can liner, and that would take care of a moisture problem and still be really cheap and cost effective. I've supplied all of you with this little letter, and for the crowd, if you want a copy, I'll give you one. This is a resolution I wrote for HB 316. And the funny thing is it's still pertinent today. So I just like to read off the be it resolved parts that we were asking in 2019. Actually, we've been asking from probably 2015 to have secure and safe from hacking or alteration voting systems. And also now we also have to add that we want safeguards against ballot stuffing. We want a secure system that produces a human readable paper archive that is recountable to the level of voter intent. And I've added and retained as physical evidence with public access. And also be it resolved that we do not want to use any computerized interface between voter input and ballot production. Even though we now have a ballot marking device, if it can't be read by the voter, it's no good. And number two, any voting system should not be connected to the internet. So that's just the revision of that resolution. But what I would like to address more seriously is Judge Totenberg's Curling versus Raffensperger opinion that our current election system violates sections 21(2), 300A2, and that the ballot marking device is not being producing a human readable text or elector verifiable ballot because the accumulated votes are in the QR code, which are not human readable. And then secondly, Judge Totenberg also noted 21(2) 7.1, again, that the ballots being marked shall also be in a format readable by the elector. So those are my two comments of things that really need to be addressed. That's more important, or is probably the most important thing, is that our election system needs to comply with other Georgia law. So furthermore, I would like to see that you place language into the statute, which basically states that any batches of ballots, whether they be mail-in or actual day of election ballots, if they don't have proper chain of custody, they shall be considered null and void and shall not be counted because they're not really valid. If they don't have a chain of custody, a proper chain of custody, how can you guarantee that there were actual real votes from a real voter? You can't. So I'm really glad to see that you're allowing access to the ballots after the election, but something that's even as important is to include access to the metadata on the electronic records, as well as any of the database entries and router trace logs and server logs. So we can actually see where the votes came from. You've probably seen demonstrations where ballot images were scanned in, and then the SHA file was, for several of the batches, was exactly the same timestamp, yet the scan of the ballot was differing timestamps, which is impossible on a computer system unless you're doing cut and paste or actual hacking. So again, I'd like to see public access to the router trace logs, as well as the server logs and the metadata for all of the data input from the election. And for that, I'll yield for questions.
Thank you, sir.
Thank you.
All right. Salek Sahani. If I got that right. Oh, okay. Come on over, please. All right, if you would introduce yourself and then I'll let you do your statement.
All right, thank you so much. Good morning, Chairman Gunter, members of this committee, my fellow Georgians who are here in attendance today. My name is Salik Sohani. I'm a senior community organizer with the Georgia Muslim Voter Project, also known as GAMVP. And GAMVP is a nonpartisan, nonprofit organization that's dedicated to building power for Georgia's diverse Muslim communities through civic engagement and voter registration. And we serve communities that have been underrepresented in our state for far too long. And I'd like to begin by expressing our opposition to the substitute of this bill, HB 1464, which was dropped only a couple of hours prior to this committee's meeting yesterday. And although I understand that you all are especially busy at this time of session with crossover day coming up very soon, this blatant disregard for transparency belies your duties to the members of the public that you serve. Dropping this 40-page bill so close to this committee's meeting time yesterday gave very limited time for organizers like myself and members of the public to read and analyze legislation that could have massive implications for our democratic process going forward. And we deserve adequate notice about this legislation, especially because it concerns our election processes, which are absolutely central to the founding of our country and to our democracy. And as I have said many, many times before, Georgians deserve better. This omnibus bill adds further restrictions to a voting process that was already hampered by the effects of SB 202. Section 7 within this bill reaffirms the limitation on ballot drop boxes imposed by SB 202. Limiting a county's number of drop boxes to 1 per 100,000 active voters severely reduces accessibility for voters who may not live near a polling location, especially our rural voters, who many of you here represent. The implementation of this requirement would mean that at least 126 of Georgia's 159 counties may only have one ballot drop box for their entire county. And this is information I gathered from the 2020 census, by the way. Additionally, the potential presence of law enforcement at ballot drop box locations may intimidate voters, especially voters of color who have been historically targeted by the police. We encourage this committee to amend this section to provide additional drop boxes in each of our counties and to not require law enforcement's presence at drop boxes. This bill also adds tremendous burdens on our selfless election administration officials and poll workers. Sections 1 and 3, which make it more difficult for state election boards to receive grants and funding from non-governmental organizations, would drastically reduce the abilities of election administration officials to obtain the resources and staffing necessary to mitigate long lines and ensure voting in person is smooth and easy for all Georgians. And whereas all 159 counties received $43 million in funding in 2020, these limitations would result in a projected 95% decrease in funding for all 159 counties, down to approximately $270,000 for all 159 counties this election season. And although we recognize that the security and integrity of our elections is essential, the ceiling requirements within sections 11 and 12 add strenuous burdens on our already strapped election administration officials, and a few of whom recognized yesterday that these requirements would further stagnate their ability to count ballots. And so we encourage this body to add amendments that hopefully slightly loosen these requirements and also to provide provisions that support our election administration officials.
All right. Thank you, Mr. Sohani.
course.
You're out of time.
No, that's all right. Appreciate you.
Okay. Yes,
Thank
sir.
you so much.
All right. So I think I'm reading it right. Desiree Jones, is that right? Okay, come on up. All right, Ms. Jones, if you would introduce yourself and then give us your statement.
Yes, sir. My name is Desiree Jones. I'm the policy associate at the New Georgia Project Action Fund. And I am here on behalf of our organization to oppose this bill. Since our inception in 2014, the New Georgia Project has helped over 500,000 Georgians register to vote, and this year we'll be turning out over 150,000 Georgians who would not otherwise vote in the 2020 election. We care about elections, we care about access to the ballot, and yet here we are just shy of 2 months after Governor Kemp saying he didn't want to overhaul, quote, the best election integrity act in the country. But yesterday, the committee dropped a surprise 40-page bill doing just that, overhauling much of SB 202 and trying to change rules again ahead of what might be historic elections. While we see many problems with this bill, we'll stick to two main issues. First, we continue to see local elections boards putting forward proposals to close polling places, to end Sunday voting, and to cut hours for early voting. And why? Because they need more funding for their staff, for their light bills, for their legal fees. And yet this bill would strip them of another opportunity to bring much needed funds to our counties and to support our elections, to ensure we have staffing and resources for secure, accessible elections, to allow highly partisan state election board control over where funds would go if they were to apply for grants. It would almost ensure the counties with the highest need would be straight out of luck. Our elections staff and supervisors don't deserve to have to cut through divisive red tape just to get the funding our state should be supplying them with in the first place. And secondly, this bill I'm so sorry. Secondly, this bill's opened the possibility to overcriminalize people by expanding and loosening the definition of intimidation with poll workers and poll watchers. While we applaud all efforts to protect, defend, and celebrate our critical poll staff, creating new ways to charge Georgians with felonies is unnecessary. We already have laws that make it a crime to commit violence toward and threaten others. Instead of furthering expanding the criminal legal structure in Georgia, we should instead stop creating bills like this that play into the big lie and imply wrongdoings in our elections workers and threaten their lives. In short, this bill is an attempt to clean up last year's mess, a mess that we and so many others told you would come back to haunt you. And we urge you all to vote no on this bill until all harmful provisions can be removed. Thank you.
I have a question for you. Hold on.
Oh, yep.
Who's 26? Oh. Pro Tem Jones?
Thank you. I just wanted to ask, are you aware that it is currently a felony to willfully prevent a poll officer from performing their duties, and that this just clarifies it and frankly narrows it up a bit?
And I don't think that needed to be narrowed. It's already a crime like you stated. And so there's no need to really do that when you already did it. We're saying that you've already taken the necessary steps to protect our poll watchers, and we're grateful for that. And this bill is adding unnecessary, harmful, damaging charges and felonies, and making these crimes more stringent. We don't need to be over policing and over criminalize people because those laws already exist. There's no need to make it any more stringent than it already is.
I have to say, I would differ with you. I don't think this makes it more stringent, it just clarifies what particular actions would constitute a felony, whereas now it's overly broad, but thank you.
Thank you.
All right. And Cindy Battles.
Good morning, ladies and gentlemen of the committee. Chairman, thank you so much for allowing public comment today on this bill. My name is Cindy Battles, and I am the Director of Policy Engagement at the Georgia Coalition for the People's Agenda. The first thing I want to talk about a little bit, we've heard for a couple of weeks that this omnibus was coming, but it still seems to me that this has been sort of a rushed process, especially given the fact that we saw 2 substitutes yesterday. I understand subs are part of the process, but 2 subs is a little quick. We've talked about this during HB 316 and SB 202, that when things are done this way, y'all end up having to come back and clean up language. And a lot of what we're seeing in this is cleanup language. With that said, I'm going to talk a little bit about a few things. Section 1 and 3, the process that y'all have come up with for counties to get funding, that's not how grants work. Maybe we need more nonprofit folks to run for office, but they're not going to apply to give us money. It has to go the opposite way. This really hampers the counties, especially as y'all are making elections more expensive and a little more complicated to run. Whether you think that's a good thing or not, it's still more expensive and counties need money. They're telling y'all they don't have resources. During the 2020 primaries, we were sending boxes of PPP to counties, and these sections would make it to where we couldn't have done that. Section 4, if you can say a large number of voters voted absentee, subtracting them may work, but it adds to the duties of election staff. And then maybe I've talked to election staff and this is what they want, but we've talked about this before and it was taken out of SB 202. I've got serious concerns because you're also allowed to subtract inactive voters. So 2020, we saw a vast improvement in wait times. If this section happens, very likely what y'all are going to see is 2018 lines, which were hours and hours long. So I have issues with that section as well. Section 5 regarding the third-party absentee ballots, part of that language is something we specifically asked for. So I'd like to thank y'all for that. Where you're taking out that this is not a government, official government, et cetera. We had asked for that. So thanks for that. Line 684, changing fairly to meaningfully, gives us concern because it should be better defined. I think that you're setting up an expectation of what poll observers and poll watchers are going to get as far as an experience and what they're going to be able to see. I think this, as well as some other stuff that y'all have passed this session, means that y'all are opening education and election staff up to harassment that y'all would never put up with in this committee room. So if you're going to change that wording, I think you need to put some parameters in there so poll observers don't come in thinking they're going to get something that they're not. Lines 892 to 903 seems to be an older version of Chairman Blackman's bill. We've got some issues with that. We know that it's worked in Colorado, but it works in Colorado because there are guardrails and guidelines for how folks can observe ballots. So if you're going to keep that in there instead of using his most recent version of the bill, we think that those guidelines should be added as amendments. Those suggestions are part of the public record, and I'm happy to send the committee a list as well as the other organizations who have asked for those. I'm sure that they would be willing to as well. I think that's the same is true in lines 926 through 933. Section 17, we also have issues with creating new crimes when existing crimes on the books can be used. I appreciate the President Pro Tem's comments about the fact that it kind of narrows the definition a little bit, but it's still troublesome to us. And then last but not least, we oppose the GBI being given charge of the investigations into the election code. We understand that the state election board had a terrible backlog of cases, but we think that the current board and the current Secretary of State has done a tremendous job in trying to catch that up. I think that making every single investigation a criminal investigation is going to deter not only voters, but poll workers, especially when you look at how many people are generally given letters of instruction via being turned over to the Attorney General. So we would ask that I know that was the original intent of the bill, but we oppose that from the get-go.
All right. Thank you, Ms. Battles.
You're very welcome.
Well over your 3 minutes.
I am so sorry. I apologize.
No, that's okay. All right. George Balbona.
I'm George Balbona. I live in Cobb County. All right. You know that recent Georgia election laws are getting scary when the latest Georgia election code is the Halloween edition. All right. I thought I was in an alternative universe yesterday when Ryan Germany actually proposed something I agree with, namely that Georgia voters should not have to obtain permission from a superior court judge to view election records under seal with the clerk of Superior Court. I couldn't agree more. Speaking of under seal, I'm still waiting to hear from Secretary of State Criminal Investigator Trent Anding to get back with me about a complaint against Cobb County. They ordered up January 5th election ballots under seal and had them delivered across town like a pizza. Saw them do it right in front of me, held the door for the guy with the hand truck. Okay. I got some photos of it. Here are the boxes under seal. Here's the truck, elections truck. Really should be looked into. The fact that that can happen is disgraceful. Last September, Gavrio, the Georgia Association of Voter Registration and Elections Officials, held their conference on Jekyll Island. Several presentations were given. I submitted an open records request and received them all. One in particular stood out. It was entitled Checks and Balance. And on slide 17, it explained check-in equal voter, scanner counter equal ballot, voter equal ballot. If off, oops. That's unacceptable. Any voting system that regularly permits properly checked-in voters to not have their ballot scanned and properly counted is unconstitutional. Before yesterday's meeting, I asked a few elections officials if voter checked-in totals off the poll pads ever differed from the number of ballots scanned on the ICP ballot scanner. They all claimed this had never occurred. Please pardon me if I'm skeptical. I live in Cobb County. My election director is Janine Evler. She won the 2021 ANHIX Award. Janine is being held up as an example of excellence in elections administration. Last September, the SEB heard my complaints against Cobb County about multiple issues I witnessed firsthand during the conducting of the 2020 primary and runoff elections. In my statement for SEB case number 2020-077, I have a transcript of my comments for everybody here. I explained, no one is expecting perfection. I wasn't. I just wanted what I always want, fair, secure, and transparent elections. If any problems occurred, I expected elections officials and poll workers to be honest and forthright about them. I think that's called integrity. Maybe you guys should look into that. So at 5:21 a.m. on the morning of June 19th, 2020, the morning the primary elections were being certified, Janine Evler wrote an email to David Greenwald, the Southeast election director for NoInc, the poll pad company. She stated, quote, "The numbers recorded by the poll workers on the recaps do not match the numbers of votes cast, and there are no paper voter certificates to compare numbers as we had before. Some are off by hundreds, and there appear to be synchronization issues, and some are off by 10 to 20, and are probably caused by duplicate cards being created. There doesn't seem to be a way to reconcile the check-ins to the ballots cast," unquote. State Elections Director Chris Harvey was also CC'd on this email. Did you hear about any of this on the news? I didn't. Somebody should tell Ann Hicks. I've got the email right here. I got copies for you. Okay.
Your time is over. Or
That's a quick 3 minutes. Last but not least, can I just say one thing real quick?
one thing. Go.
And I have a copy of what I wanted to say to hand out to you. The Secretary of State's office fabricated false felony allegations against me. Okay, I'm all too painfully aware about OCA 21-2-566 subsection 2, which they claimed I did. They said I interfered with an election, and more shockingly, that I threatened violence. All created out of whole cloth. If you know any good civil rights attorneys, this is a slam dunk.
Okay.
I'd like to shine a light on this.
All right. Thank you, sir. Julie Adams.
My name is Julie Adams, and I'm a resident of Fulton County. Thank you, Chairman Gunner and the esteemed committee members for letting me speak today. Much of this bill discussed today helps ensure election integrity. However, Section 10 of the bill that you are discussing today discriminates against nonpartisan and libertarians from poll watching. If this section is not stricken from the bill, you are denying this group of citizens from observing our elections. This part of the bill is not an effort towards free, fair, and transparent elections. It is discrimination to a section of Georgia citizens. During our recent 2021 municipal election, I had a small group of poll watchers that were credentialed through the Constitution Party of Georgia. To my knowledge, we are the only group that reported significant findings to the legislative body. I presented these findings to Senator Max Burns, chairman of the Ethics Committee, with the purpose of assisting in considering of new legislation. These findings showed many areas of concern in our elections, and many of those were around chain of custody issues and ballot drop box problems. Section 10 would prohibit nonpartisan and independent parties such as the Green Party, the Libertarian Party, and the Constitution Party from participating in election integrity and banning them from observing our elections process. Georgia has 159 counties, and some of them do not have the two major parties represented in those counties. I feel this would ban and exclude those citizens from any poll watching in their elections. Please do not disenfranchise any Georgia citizen. Strike Section 10 from this bill. All Georgians have the constitutional right to observe our elections. We all should aim for free, fair, and transparent elections. Thank you.
I have a question for you. Chairman Jones?
Yes, ma'am. I just
Pro Tem
wanted to
Jones.
clarify that Section 10 doesn't change who is allowed to be a poll watcher. Only the underlined words are the words that are changing current law. And so whatever parties are allowed now will not change. All this does is clarify that the poll watchers will actually be able to watch something meaningful versus just what they can watch.
Okay.
And that's my.
I felt that that section discriminates against everyone that's not the two main political parties and credentialing. Okay.
Clean that up.
Okay.
Thank you.
All right. Didn't mean to ignore Chairman Martin online, but I see he has his hand up. Are you still wanting to ask a question?
Well, yes, sir. It was a speaker or two back, but I'll hold that for now. Could I ask the attorney to follow up on Pro Tem Jones' point? I believe the lady may be referring to in Section 10 the several additions where it says whose name appears on the ballot. It appears to add some additional poll watchers or poll officials, if a party has a candidate on the ballot. And I would just ask Mr. Morelli, I believe that's who's there. I'm looking virtually. It just gives them additional people at the polls, does it not, Mr. Attorney, and doesn't eliminate people that aren't affiliated with parties. Am I reading that incorrectly?
May I respond to that? It does eliminate groups that don't have a person on the ballot and just have write-in candidates.
I understand that's what the lady understands, and I'd like to get Mr. Morelli to opine on that for me to see if he concurs with you. If he does, then I see your point. I just want to make sure that can Mr. Morelli do that if the chair will allow?
Yes, he may. Go ahead.
It's my understanding that those political bodies, which would be those smaller parties other than the Republicans and the Democrats, to take part under these sections under the current law would have had to have a candidate on the ballot anyway. So this is just kind of clarifying that existing law.
Okay, and Mr. Does that prohibit somebody unaffiliated from being a poll watcher?
Qualified writing, they're eliminating anybody's got a qualified writing candidate. They have to have their name on the ballot, and that's why it's wrong. They did this intentionally.
Mr. Morelli?
So I've been informed that the additional language here probably would, do what the speaker is saying.
So my question then on lines 617, 618, independent candidates would still have the ability as well. I mean, I guess there's just some more ferreting of that as we move forward in the process. I don't think it would be our intent to let to prohibit a Georgian from being able to be a poll watcher without being affiliated with a candidate, would it?
From what I've been informed, the intention was to prioritize the limited space in the polling places to those parties and political bodies that actually had candidates on the ballots. Since there's limited space, as I understand it, the intention was to make sure that the certified watchers for those candidates were actually there, whereas organizations which did not have a candidate on that particular ballot could still observe, but if there was a lack of space, then the poll managers and poll officials had some kind of discretion on picking and choosing to maximize the interested parties who could actually observe the process.
Absolutely. That's what, thank you, gentlemen. Mr. Chairman, I'll follow up with the author later, but that's what I thought. It was not to outright prohibit folks, but to give, as the learned attorney said, people with interested, more interested action, if you will, i.e. a candidate on the ballot priority, so that they could be there, but not to prohibit others. And we can continue to work. Thank you.
All right. Thank you, Mr. Chairman. Pro Tem Jones.
No, I'm just saying we'll continue looking at this.
Okay,
I
all
appreciate
right.
you for clarifying that and bringing that up, ma'am. Thank you.
All right. I think so. Thank you. How much time we got left? Okay. Is there a Brit here? I can't read the last names. Yes, there we go. If you would introduce yourself.
Yes. Good morning. My name is Brittany Jones Chukra, and I am the co-founder of Protect the Vote GA. Here we are yet again with another bill attempting to attack voter rights. After many organizations, pastors, local citizens, activists, and even young people who can't even vote yet have shared how important voting is and how they want easy access to vote. HB 1464 includes provisions that risk criminalizing voters by giving the GBI original jurisdiction over election-related investigations, banning donations of food and water to counties and polling places, and more suppression for voters. Instead of empowering voters and future voters, we are starting to see a pattern of going backwards. Instead of protecting the vote, which is so precious to many, we are adding more unfunded mandates, administrative tasks which are nearly impossible to execute, and unnecessary criminal penalties, which will certainly serve to prevent citizens from participating in elections as volunteers. It's almost as if you don't want us to vote at all. We want more access and fairness. We have rights, and our votes represent our voice. Please do the right thing.
Thank you. All right. I believe I have time for one more. Susie Voyles. Is that right?
Good morning. I'm Susie Voyles, Fulton County. I was a 22-year poll manager, 22, and I counted that as a privilege. I did that in a nonpartisan sense with both of my Republican and Democrat officers who looked at this as a profession. With all due respect to Chairman Martin, I heard yesterday that he believed my ballots that I observed in the recount were adjudicated ballots. And with due respect to him, because I do respect him, I would like to say that was hearsay. I have done this, as I said, over 20 years. Those ballots were not adjudicated. They were printed with toner. And one of the things that stood out to me, besides the no folds, if they were adjudicated, they would not have been done on those papers. The paper was flat. It was of a different texture. But the thing that stood out was every single vote, from the president down to Fulton County Soil and Conservation Officer, was exactly the same on 107 ballots. As long as I have done this, I have not seen every vote filled in, every referendum filled in. These were done as practice ballots by Bridget Thorne, which she did in accordance with, she thought she was setting up the machines, but those practice ballots made their way into the count. One of the other things I really want to applaud you for in this bill is that the ballot images must be full public record. If this had occurred, there would be no question about the ballots that I saw. This would not be hearsay. My testimony would not have been discredited. And one of the other issues that I have to say, along with another gentleman in here, is the fact that I was brought before the state election board without my notice, denied my due process over a 2018 election, found guilty. But the interesting thing was, I was found guilty of denying people the right to vote. Every person who worked in my poll, whether they were Republican or Democrat, will attest to the fact that no person was denied the right to vote. I wasn't even known this was coming forward. And with that being done, if we had ballot images, if we had appropriate items that were to come before the state election board, they would not be in order to attack a person, to discredit a person. And I would not have been denied my due process. But the interesting thing, and I'm not asking for prosecution, please don't misunderstand me. It said this case is closed. If I had been found guilty of something that was really egregious, that would have gone further. Furthermore, as far as poll watchers are concerned, we have poll watchers who are being prosecuted from both parties. That should not be. The second thing that is so important, we have no bite to our law. We have no penalties. If you look at Oklahoma, Alabama, and Florida, Alabama and Florida are right next to us. Florida's in our same circuit. They have penalties to things that need to be addressed. Those things need to be addressed in our law. If somebody transgresses our law, for example, one affidavit turned in was a couple that came from California, voted at his mother's former property. They voted in California too. Voted in his mother's former property in Gilmer County. He was turned in by my friend, his aunt. Then he went across to North Carolina and voted again. Now that's bad enough. He was sent a postcard. You can still vote in Gilmer County. But what's the worst part? That affidavit was turned in November 5th. He was not even challenged when he came back and voted early, December 29th. That is wrong. That is wrong. Why are we prosecuting well-meaning poll watchers who just want to observe what is going on and not prosecuting those who transgress the law? If you have questions about the ballots that I saw, do not believe what somebody else has told you. I suggest you ask for firsthand eyewitness. I know Barb Hartman was here yesterday, but the other thing we need to go back to, and I heard somebody mention this, we need to go back to the paper certificates. As everybody scribbles on the poll pad, nobody can verify that signature. Signature verification, whether it's an absentee ballot or whether it is a ballot in person, needs to be verified. And that paper signature adds two things. It's like balancing a checkbook. If you have X amount of certificates, X amount of people entering the poll pad, X amount whether you use paper ballots or whether you use machines. Those things right then and there can be verified. You've got a triple balance, and then you have your end tapes. And one of the things that I just find so egregious about Fulton County is they are far too often able to skirt the law. This is not fair to any voter in Fulton County. It is not fair to any other county. And there should be a time in this bill. If Florida can do it by 9:38 and get their votes in across the state, Georgia can get this in on time, whether it's Muskogee County, Fulton County, Chatham County, I don't care where it is. The smaller counties should not have to wait for the bigger counties to see how many more votes they need to turn in. Thank you.
Thank you, Ms. Voyles. All right, ladies and gentlemen, we're really out of time for any more public comment.
Mr. Chairman,
Favorito, I don't- no,
you agree?
No, I'm not hearing from you today. Okay. All right. We're going to start on the vote of the bill, and we have several amendments. So I want to get started with that. Is there any further discussion by the committee on this bill before we? All right, let's see. This is okay, Representative Bernal.
Thank you, Mr. Chairman. I had a question. Is it too late to submit any more amendments?
I'm sorry, what was your question again?
Is it too late to submit any more amendments?
No, it's not.
Okay, thank you.
Okay. And Representative Alexander?
Thank you, Mr. Chairman. My comments are centered around the GBI involvement. I think we've heard from some speakers today, some speakers from yesterday. I know my election supervisor was here yesterday. Anytime we add law enforcement and GBI involvement, is really on the border of intimidation to our voters, to the poll workers, and to the activists that are involved. It's really hard for some counties to recruit poll workers right now, and threatening to bring in a GBI will really just make it worse. That's my thought. For the authors of the bill, there's several concerns that I have around the GBI involvement, and these are questions. Has anyone spoken with the GBI about their involvement? They really don't know the process of elections, so that's some concerns to me. Have they talked to the election supervisors? We had the one yesterday, we heard from one today. There's several across the state. Have we talked to them about the involvement of GBI? That's the one question. And then I have a couple of follow-ups.
Go ahead.
Thank you, Chairman. Yes, so we have had discussions with GBI and also have had discussions with appropriating funds for the GBI. Just to clarify, GBI can investigate right now elections issues. They just have to be requested to investigate. This gives them original jurisdiction. So if they deem necessary, they can investigate. GBI can investigate right now if requested to do so.
Okay, so further follow-up, what can the GBI do that the Secretary of State investigators can?
The GBI is the highest law enforcement agency in the state of Georgia, who is capable of handling very detailed investigations, including bank fraud, wire fraud, things of that nature that this comports with, this type of issue comports with.
Okay, further a follow-up, Mr. Chairman. Help me understand, and maybe, everyone looking, what are the cases of election fraud where the GBI would have investigated this in the past 2 or 3 elections?
Well, if there are allegations of fraud within the election, I think that you would want the law enforcement agency that is best suited to investigate being that investigative body.
Correct, but I'm saying in the past elections, where has that occurred where the need of the GBI would have been expected?
There were several allegations of fraud.
That's what I'm asking you, if you can tell me what those cases are, as it relates to that, where we would have called in the GBI, and was that done?
The allegations were numerous. I think many of the people here even attested to the allegations of fraud that they're alleging. So, I mean, I'm not sure what you're asking me.
Right. So in other words, we're proposing that the GBI investigate this, but isn't that simply just going along with that big lie?
I refuse to answer that question.
Thank you.
Okay. Representative Williams.
Yes, sir. Thank you. I'd like to respond to some of that, with the Secretary of State being an elected position, then you do have whatever partisan party that Secretary of State belongs to and their employees. I'm not implying anything, but there's the perception. I know that Secretary of State uses post-certified inspectors to do those investigations, but the GBI there again is very qualified and they're nonpartisan, and you have people and the politics is out of it. And I have the utmost respect for them and feel like I could set up an investigative division for elections and specialize in that, such as they do bank fraud and those other items. I just wanted to clarify that. Thank you very much.
All right. Thank you. Representative Douglas.
Yes, thank you, Mr. Chair. I've sit down and listened to this testimony over and over and over again, and from Senate Bill 202, and I thought we would be finished, or you guys would be finished dropping these type of bills to hinder our state. Considering our state was at the center of national attention, why would we want to bring more attention and discord to our state when we are already in that spotlight? I just want to open with that, but I do have a question here. As I didn't have much time to look over this bill, considering the time that was given to us, but we have 159 counties, and each of these counties have a unique election administration that needs of concerns need to be met. In section 1, 3, 18, and 19 is limit the ways and ability of counties to address their individual needs, especially as it relates to grants and donations. Why is this body taking up measures that will cripple election administration and create even more burdens on them that they already have today? That's my question or comment.
All right, I'll take it as a comment.
Okay, thank you.
Representative Burnell.
Thank you, Mr. Chairman. I still have concerns about the reduction of the ballot drop boxes and the limited time that voters will have access to them, and the fact that we're going to use a poll worker to sit next to them. It was said previously that everyone has a drop box at the end of their driveway, and that is not true. Many Georgia residents live in apartments and other areas, and we know that we're having the problem with still having problems with the post office. And so I would like to ask an amendment that we be able to increase the number of drop boxes across the state to make voting more accessible to our voters. We have so many voters. I know that we're allowing them to be able to take off from their jobs if they need to go vote, and that's doing early voting. But we still have individuals like our police, fire, doctor, lawyer, Indian chief, that they don't have time. And so the fact that we are limiting the time, the drop boxes were secure, and I understand that we used them during COVID. But as stated previously, we are still using Zoom, and it's working really well for all of us. And I know it wasn't a law then, but I don't know why we are still limiting access to Georgia voters. And so that's the amendment that I would like to bring.
All right. Do you have, well, we'll get to that in just a moment. We're not in that posture yet.
Okay,
Be
thank
right-
you.
Be right back to you. All right, Representative Williams.
Thanks, sir. You know, it goes back to drop boxes. We never use those things till this pandemic. The pandemic has calmed down. But I'm against drop boxes. We don't need them. If anybody that wants to go to the grocery store can go to the grocery store. Anybody that wants to go vote can go vote. I did elections for 16 years and, you know, there's precincts. They're all throughout your voting district. These gifts people keep talking about, you know, the population of Fulton County is over 1 million. Population of Wilkinson County is 9,000 people. Who do you think is going to give Wilkinson County a dime and they're going to pour the money where the voters are? I mean, if we're going to be fair, let's be fair across the board. If they want to give money, give it to the county commissioners. Let them divvy it out, go on to the state. Poll workers, you know, I keep hearing this, or poll watchers. Yeah, we need poll watchers of all parties. They need to take an oath. They need to be given a code of conduct, what they're expected to act like when they're there watching. But they also need identification that they are who they are and they have taken that oath under penalty of law, that if they interfere or don't do as they're supposed to do. The signature verification should have never gone away. I'm a firm believer in that. That should still be there. That's my 2 cents worth. I'll get off my soapbox. Thank you.
Representative Burnell.
Thank you, Mr. Chairman. We were sent down here as legislators to represent our constituents in our community. And while I can drive to go and vote, while I do live in a house that does have a mailbox at the end of my driveway, but there are many people all over the state of Georgia who do not have that same access. And so I'm not here just for Rhonda Bruneau. I'm here for the constituents of Georgia to make sure that they have fair elections, not just fair, but also that they have access to the ballot boxes. And yes, while we are a country that is known for inventions, and so to say that the invention of the drop box is no longer needed because we don't have COVID and we should get rid of it, then maybe we should get rid of cars and we should start back walking again. So I don't understand why we're so against drop boxes, and I'm just going to leave that alone. I know Dean Smyrie would like for me not to say too much. Thank you.
All right. All right. I would entertain a motion at this time. I have a motion to pass and a second. Any further discussion? All those in favor? Well, hang on a second. We got the amendments to take care of. About to jump ahead here. And that might clear up some of the criticism we have of the bill if we can get through these. Does anybody on the committee have one that we want to take up first? Which one are you? 22. Chairman Powell.
Thank you, Mr. Chairman. I had spoke to council just a minute ago before the meeting started about, and I'm satisfied with all of the language on chain of custody with the exception of the one that was taken out, excuse me, that would deal with a chain of custody on the secured paper that's delivered to the elections, to the election boards. And I think that I still believe, even though there's objection from election boards, that there needs to be some kind of a chain of custody for the assurance in people's minds that everything is being properly accounted for. Now, because of the structure of this bill, is so much more wider than what 886 was. If you look through here, all of the different chains of custody, from ballots to drop box security to, you know, every and all is spread throughout this whole bill. And I'd asked counsel, Mr. Morelli, if he would, to look at 886 for that language that dealt with that chain of custody on the security paper. And if he has that, I'd like for this committee to consider adopting that language, if he would give that language to us.
Sure. So what we'd be doing to make that an amendment to this bill would be on line 777. We'd be probably adding 2 new subparagraphs. And I'll read out the language that was in 886. Just for reference, it's lines 19 through 33 of House Bill 886 as substituted by the House Governmental Affairs Committee. And that language is, at the time the security paper is delivered to the election superintendent from the supplier of such paper, the security paper shall be placed in locked containers. Such containers shall be sealed with a numbered seal, the number of which shall be recorded on the tracking form maintained by the superintendent. Each person who takes possession of a container in which the security paper is enclosed shall provide written confirmation with date, time, and signature that the number of the seal on the container matches the number recorded on the tracking form, and that such seal has not been broken or otherwise tampered with or compromised. The tracking form shall also serve as the chain of custody document on which each person who takes possession of a container shall sign for the security paper therein. Such form shall remain with such container until the security paper is used or destroyed in accordance with law. And then the second new subparagraph would read, security paper shall only be removed from the locked container for use as ballots or for necessary training or maintenance of election equipment. Anytime security paper is removed from a locked container, the removal, amount of paper removed, and the reason for such removal shall be noted on the tracking form.
And that is your proposal? for
That would be
amendment?
my proposed amendment.
Okay.
And I want to thank council for finding the spot to put that. I would also like to ask a question. I know that Mr. Germany explained yesterday the problems that the election officials had brought forth. And I want to ask, do you have any thoughts about anything that would make this work that might relieve the concerns from the elections, the various county election officials, even though I still tend to believe that there's a necessity to have this chain of custody?
Thank you, Mr. Chairman. I don't have any thoughts off the top of my head. I think some of the election officials made their concerns known yesterday, and I know they've made some concerns known to you guys in emails as well. I think the concern is, basically as they go about their duties, these are duties they have to perform. They have to perform them in a timely fashion. So we want to make sure that while that process is secure and does need to continue to be secure, we got to make sure they can do it in such a way that doesn't, slow things down too much or really get in the way of them actually completing those duties. So I don't have any changes off the top of my head, but I think those are the concerns that I've heard from election officials.
Mr. Chairman, I would like to make the language that Mr. Morelli gave in the form of a motion.
All right. All right, got a motion and a second. I'm gonna call this the Powell Amendment. Any further discussion on the Powell Amendment? Ready for a vote? All those in favor say aye.
Aye.
Any opposed?
No.
All right, ayes have it. So that's been adopted. Any other amendments? Let's see, hang on. Chairman Blackman.
Thank you, Mr. Chairman. I believe we had heard House Bill 933 in governmental affairs a couple of times and had made some suggested changes that were incorporated and had some really good testimony and feedback, and believe we got it in in a better form, acceptable form. And I think the substitute put in this bigger bill, I think Stuart's got some language that would replace it with the newest that we presented in governmental affairs a few days ago.
So to bring this bill in line with the latest version of House Bill 933, what would need to change is on line 885, the underlined words "to limit access" would be deleted. Then lines 892 through 903 would be deleted. And lines 926 through 933 would be deleted. And then up on line 910, the underlined paragraph 1, that designation would be deleted, since the paragraph being added in lines 926 and 933 will not be added.
And just to explain, this is a transparency piece that was brought, and it's a very minimalistic approach whereby the courts would retain possession and they would still remain secured, but you wouldn't have that seal, so that this falls in line with the ballot images as open record, and of course the paper backup, and then for ballot inspection, subject to open records as any other law we have in Georgia. So.
All right. Any discussion on the amendment? Or have we got a motion for the amendment?
Move.
Second? All right, motion and a second. Any discussion on the amendment? Any questions of the author of the amendment? All right. All those in favor of the amendment, say aye.
Aye.
Any opposed? Ayes have it. Adopted the Blackman amendment. All right, any other amendments? All right, let's see, you're 24, 26. Okay, Pro Tem Jones.
I'd like to amend section 10. And I'd like to, beginning on line 699, there would be a period after the word space, and then the remainder of the section would be deleted. So lines, part of 699 to line 741 would be deleted.
All right. Go ahead.
So to clarify, the new proposed language would be deleted, or the existing code language as well would also be deleted?
Oh, I'm sorry, just the underlined.
Okay.
Yes, sir, to make
Thank
that
you.
clear, yes.
Yes, ma'am.
Only the underlined words that were being added.
All right. So strike out after space on 699, all the underlined there.
Oh, the underlined, that's correct.
Then we jump over to 725 and all the underlined down to 732, or actually over to 741.
Yes, sir.
We'll go out. All right. Does that cover it?
Yeah. Mhm.
Okay. All right. Do I hear a motion on the amendment?
I move.
Is there a second?
Second.
Have a motion and a second. Any further discussion of the amendment? Any questions of the author of the amendment? Hearing none. Yes, I'm sorry.
Quite all right. Thank you, Mr. Chairman. I have discussion because that's doing away with the oath that the poll watchers would be taking. And that's something that I really believe in. I'll allow this, but I'll continue to work with this bill as it goes forward to try to have that back in there. I just feel that's something that's very much needed, but I just wanted to go on record that I will work with the authors of this bill on trying to get that oath back in there. And having those poll watchers identified with a card that they have been trained. They do understand the code of conduct and they are needed, but I'll reluctantly move forward with that. Thank you.
Thank you, Representative Williams.
As well, to see if we can come up with some language that accomplishes what he wants during the process.
Okay, all right. Any further discussion? Hearing none, all those in favor of the amendment?
Mr. Chairman, Mr.
sorry.
Chairman,
Oh, sorry. Chairman Martin, if you would, go ahead.
yes, sir. If I may, just briefly under discussion, I was not able to get an amendment drafted, but I'm still inclined to look for support to include language to require our elections board take public comment and give them the flexibility to handle the decorum in their meeting, the time, place, and manner. But just wanted to recommit to that and work with our Senate colleagues as the bill moves forward. Thank you.
Thank you, Chairman Martin. I keep missing you over there on the computer. Sorry about that. All right. Ready for a vote? All those in favor of the Jones amendment, say aye.
Aye.
All those opposed? All right, in the chair's opinion, the ayes have it. So add on the Jones amendment. Any other amendments? Oh,
Thank you, Mr. Chairman. I'd like to propose an amendment to Section 7. This is an issue that one of my constituents highlighted for me and that we also heard discussed yesterday during our public commentary. This would affect lines 277 through 279. On 277, delete the word closed and add the word locked. And on line 279, do the same, delete the word closed and add the word locked. And this would provide for the locking of the drop boxes instead of just the mere closing.
okay. Do I hear a motion on this amendment? Hear a motion, second? I hear a second. Any further discussion on this amendment? All right, hearing none, all those in favor of the amendment, say aye.
Aye.
Any opposed? All right. In the opinion of the chair, the ayes have it. The Rich amendment is on. And just for the record, that we have that printed out. It's AM 470036. You have it in front of you if you haven't noticed it on your in your paperwork. All right, any other amendments? Pro Tem Jones.
I see an amendment here, AM 470037. I don't think we did that one, did we?
No, we haven't. Okay. 25 or 26? 26. All right.
And it, on line 942. It broadens the language here, and you can see what's in the amendment. It strikes the words including any poll officer, so it remains any person.
You may want to pull that mic right into your,
Okay.
yeah, because
Yeah.
it's hard to hear you.
So we have AM 470037. It strikes 4 words, including any poll officer, so that it reads any person who willingly prevents.
Okay.
Just to clarify, that amendment would also strike the proposed language in the substitute before you or certified poll watcher.
Yes, sir. Thank you.
So it would just read any person who willfully.
Correct. Yes, Mr.
Straight in
Chairman.
that way.
Yes, sir.
Okay. All right. Any further discussion of the amendment? Do we have a motion on that? And a second? All right, have a second. Any further discussion on that amendment? All those in favor say aye. Those opposed? All right. Ayes have it. We have the Jones 2 amendment. I'll call that. All right. Any other amendments? No, that's not, yeah. All right, Representative Burnell, you had an amendment, I think.
That I'm gonna pass. Thank you.
All right. That all the amendments? All right, ready for a vote on the bill. All those in favor of passage of House Bill 1464, say aye.
Aye.
Any opposed? Ayes have it. Bill passes on to rules. All right, ladies and gentlemen, thank you for your attendance today, and we are adjourned.